I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today we have another compilation video for you guys. You guys been asking for these, and we've been digging back in the crates. And the beautiful thing about some of these proceedings is that a lot of you have not seen them. Some you have seen. And what we're going to do on this particular video is we're going to make sure we put chapters in the video. So just in case you do run across one you've seen, you can jump to one that you have not. So today we're going to be dealing with two different proceedings coming out of the court, I should say, of Judge Simpson, where he's dealing with a young, defiant young man and a Moorish young lady. And we're also going to be in Judge William URICH's court and Judge Andrew Kay's courtroom. And what's going to happen with those two is they're actually going to be dealing with the same defendant, but two different proceedings. So he'll be in Judge URICH's courtroom first and Judge Andrew Kay's courtroom second. And all of these particular proceedings are definitely classics and has some classic moments. So I hope you enjoy. Know that I appreciate you guys. There won't be any commentary at the end. So with that being said, thank you again for stopping in with Sovereign Citizens Hall of Fame. I appreciate you guys. Don't forget to subscribe, like, and share the videos. With that being said, let's go ahead and jump into these proceedings.
Court does call the case, People versus TARIK Day.
Senior Assistant Prosecutor.
I am TARIK TARIK, the executor of the TARIK TARIK Living Trust and the registered owner of the TARIK TARIK ex relatione Kingdom Wilson estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant. Indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How
religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an indigenous person.
No.
So I do have
Sir, what you're about to state is incorrect.
well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a
That's
competency.
not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes. I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
With the court, ask the people to prepare the order for the competency.
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 1410 Share Avenue, apartment 3.
is that your address, sir?
Excuse me. That's correct.
All right. All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did.
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before?
Well, as I stated at the last hearing,
No, don't go through what you
additional week.
stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. And man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Court does call the case, People versus TARIK Day.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Day, who is present via Zoom. Sir, can you please unmute and state your name for the record?
TARIK Day.
Thank you, Your Honor. I do have a green form. I neglected to turn in prior to the docket. However, this is the day and time set for PCC. To my understanding, Mr. Day was referred for competency. There was a failure to appear back in October at his competency review hearing. We do not yet have a report from the Forensic Center. I'd respect this question adjournment.
Is this set for competency?
Don't have it marked.
It should be a competency hearing, and we don't have a new report.
Our office has not yet received one, Your Honor, unless the court is in receipt of one.
Well, there was the original one from August.
Yes, and we have no further evidence.
There's no further one.
Am I able to ask a question?
If you, well,
Mr. Day, you can email me or call me and we can discuss any questions you have.
Okay.
We can talk again.
I'll set a competency review hearing.
January 2nd.
I'll set this for January 2nd, 2025, 9 a.m. If
It's
we
just real- it's a
receive
small
something, if we receive something prior to then, we'll move the date up. Okay? Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Jade Latham.
Case on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt.
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man. And I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case. So what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
Pursuant
asking
to the
for
statute.
anything, and that's, I mean, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for 90.
June 6th at 9 a.m.
June 6, 2024, 9 a.m.
2002.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Jade Lathan.
Image Ganatra for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We've reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. Bond continued. Yeah.
Thank you, Your Honor.
Case, People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied 2 main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These 2 things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. Business matter. Thank you.
Thank you, Your Honor.
The letter back.
Calling case number 24 RO 04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
Very well, Mr. Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, Air near Washington, in the City of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have 3 options and 3 options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
Well, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William URICH, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
That's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority,
You
is-
don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay. If
Mr.
the-
Mathis, the
if they-
officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically? Or
Where's
are
the
you
city?
asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak? Please bring the
Court
city.
doesn't understand your question. Are you asking where it is on a map or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the Motor Vehicle Code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case.
Why are you trying to
under the Motor
charge
Vehicle
me?
Code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
Very
no
well.
one injured. You guys are
Officer Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district. And at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing.
Look for. Okay, were you on duty on May 24th, 2024 at approximately 9 p.m.?
I was.
What was the weather like at that time?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak?
It is.
What happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It,
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay.
Officer Moran, you can see that video that I pulled?
can. Yep.
Okay. Just playing that video now, Judge.
Okay.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right, so admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
What's your objection?
Because I was traveling. I wasn't driving.
Okay, overruled. Go ahead. You can answer the question, Officer Moran.
Yes, I do see the defendant in the court today.
Your Honor, let the record reflect that Officer Moran has identified the defendant, Anthony Mathis.
The record will so reflect.
When you pulled the defendant over, did you have a conversation with him?
I did.
And in that conversation, did he admit to you that he had driven through the red light?
He did.
And ultimately, you issued him a ticket?
I did.
What was that ticket for that you had issued him?
I actually issued him an impeding traffic ticket.
Okay. But that's not what he actually did, correct?
No, that's not.
Why did you issue him an impeding traffic ticket?
Mr. Mathis at the time had a good driving record. He knew what he did. He told me he admitted to it, and he had a good attitude on the road. So I chose to go an impeding traffic ticket.
I object.
What's your objection?
I never admitted to anything. Did you guys pull that up? Did I admit to something?
You'll have a chance to.
That's false.
Mr. Mathis, you'll have a chance. Your objection's overruled. This is his testimony from his memory. You'll have a chance to testify yourself and add any additional evidence here. So at this point, that is not a proper objection. It's overruled. Anything else to add there to that?
Just very briefly, Judge, what infraction did you actually observe?
I could have wrote him two infractions, either disobey traffic control device or disobey traffic signal.
And that's what he actually did, correct?
Correct.
Judge, I have nothing further at this time.
Now, Mr. Mathis, it's your opportunity to ask Officer Moran any questions that you feel are necessary. Now, I just want to instruct you, you'll have a chance to testify if you choose to in a moment. Right now, anything that you say should be in the form of a question directed at the officer. If you're going to start testifying, I'm going to have to interrupt you and redirect you. You'll have that chance in a moment. It's just to ask questions. So go ahead with any questions you have.
All right, well, for the record, is there any injured party? Do we have a sworn affidavit or complaint from an injured party?
No, there's no injured party.
Okay, so we don't have any injured party. So Judge, you've been sworn in to uphold the Constitution, correct?
I'm not on the stand. I'm not answering any questions like that, Mr. Mathis, excuse me.
So what type of court is this? Is this Admiralty Maritime Law?
Mr. Mathis, right now is your opportunity to ask Officer Moran any questions that you want to. If you're going to make some legal objections or something along those lines, you can do that in your closing. But right now, this moment in time is for you to ask Officer Moran any questions.
Okay, well, for the record, we don't have any injured parties, correct?
Judge, that's been asked and answered.
Sustained. He already answered that question.
Right, correct. I just wanted to make sure that we got that on the record. So if there's no injured party here, then why are we here? No,
Judge, I don't think that's an appropriate question for Officer Moran.
It should have been no type of charge.
Hang on, Mr. Mathis. When there's just like when you made an objection, we all waited for the court to make a ruling. That's what you need to do. So Mr. Klusny just made an objection that your question was actually more of a legal argument. I think that's what your objection was, Mr. Klusny, correct?
Yes, Judge, I don't believe there was a question directed to the officer.
So I'm sustaining that objection. And again, you can make those legal arguments or whatever the case is that you want to make at the end. Right now, it's just questions or not to Officer Moran. Anything else?
No, that's the only question that I have. If there's no injured party, you said no one was injured.
All right. So, Mr. Klusny, would you like to call any additional witnesses? I should ask you first, any redirect of Officer Moran?
Not at this time, Judge.
All right. Then any additional witnesses, Mr. Klusny?
No, Your Honor.
Mr. Mathis, will you be testifying or do you have any witnesses that you'd like to call on your behalf?
No, I don't.
All right. Mr. Klusny, then your closing statement.
Judge, based on the testimony of Officer Moran and the video, it's clear by a preponderance of evidence that the defendant committed the offense of disobeying a traffic signal. The authority for the stop comes from MCL 257.611 or 257.612. I believe that's for the traffic control device. The video in this case could not be more clear, Judge. You see Officer Moran is in the left turn lane. He gets a green arrow, and the defendant in his vehicle has a red light, drives right through the red light. If Officer Moran didn't stop, he would have hit the defendant's vehicle because he went right through the red light. It's rare that we have a video that is as clear as this, Judge. And the officer tried to give him a break by writing him for an impeding instead of what he actually did, which was disobeying a traffic signal. And I believe it's clear based on the testimony in the video that the defendant is responsible for that traffic offense of disobeying a traffic signal.
Maybe you changed.
Yeah. Thank you.
You got the light?
Mr. Mathis, your closing argument?
Well, what I would like to say on the record is no one was injured. There's no injured parties. If you guys can't bring forth any injured party, then why are we still here? I need this to be dismissed, and the funds that was issued on the bond account needs to be reimbursed to me. Period. You guys don't have any injured party here. Based on the Constitution, the Sixth Amendment, if you guys can't bring forth the accuser, then this needs to be dismissed.
Anything else, Mr. Mathis?
Not at the moment.
All right. Was there a bond posted? I'm not quite sure what he's talking
Absolutely.
about.
Judge, it looks like there was a $175 bond posted. Judge, I apologize. The file is here. I'm going to send the file into court.
Mr. Klusny, the amendment was to disobey a traffic signal, which is a okay.
I apologize, Judge. The file coming into you.
That's all right. The amendment that the people made here was to disobey a traffic signal. Is that correct?
That's correct, Your Honor.
All right. The court's heard the testimony, the arguments of the parties, reviewed the video that was introduced as evidence. The video shows clearly the vehicle driven by Mr. Mathis to go through a red light, the traffic signal at 11 in Washington. The standard here at issue is preponderance. The video showed beyond any doubt, really, that that's what occurred. Also, there's testimony from Officer Moran that that Mr. Mathis did actually admit on the roadside that he had done what was alleged to have occurred here today. That testimony was uncontroverted by any other evidence that was introduced. With that, the court does find Mr. Mathis to be responsible for the amended charge of disobey a traffic signal. That's a $150 fine. Mr. Mathis has posted a $175 bond, so the court will apply the bond to the fine of $150. There's a $25 refund coming to Mr. Mathis, and that's all for today. All right, we're all set. Thank you, Mr. Klusny, Mr. Mathis, Officer Moran. You all have a good day.
Thank you, Judge.
Thank you, Judge. Thank you, Officer.
I'm not threatening you. Say one more word and that's 30 days. 30 days.